Greetings and welcome to today's webinar, Employee Benefits 2019/2020, Finish Strong, Start Ready, presented by Quarles and Brady. My name is John Barlimont, and I'm a member of our firm's Employee Benefits team. I represent employers, third-party administrators, fiduciaries, brokers, and benefit consultants in all aspects of employee benefits law, with an emphasis on health and welfare plan matters like the healthcare reform law, ERISA, COBRA, and mental health parity. I also have particularly deep experience in data privacy and security space relating to HIPAA and with multi-employer plans. I am pleased to be co-presenting today's webinar with my attorney colleague in the Quarles and Brady Benefits Group, Mike Weber. Mike, do you want to introduce yourself?
Sure. Hello, everyone. I've worked for almost 20 years as in-house counsel with two nationally recognized trustees and plan record keepers before joining Quarles and Brady's employee benefits team about 2 years ago. I assist clients with the design, implementation, administration, and termination of employer plans and guide plan sponsors and trustees through the ever-changing landscape of fiduciary investment rules and provide advice on fiduciary best practices. When disputes do arise, I negotiate, litigate, and when necessary to achieve optimal outcomes for my clients. So before we begin the presentation, we have a few housekeeping items to go over. John, I guess I'll continue on to do these. First of all, we're going to be applying for 1 hour of CLE credit. If you are an attorney and would like to receive CLE credit for attending today's program, please fill out the CLE form located at the back of the materials found in the handouts panel of the webinar dashboard. Please complete the form and return it to the contact listed at the bottom of the document. There's also an HR attendance certification form in the dashboard materials for human resource professionals to use in self-reporting. As indicated at the beginning, we have muted all phone lines for those dialing in, and participants are in listening mode. Audio via computer, so you won't be able to speak. We are, again, in listen mode only. We would like you to be aware that this presentation is being recorded and an electronic survey will be emailed to you after the program. If any webinar participants have a question, please do type your question in the chat box located in the upper right-hand corner of the webinar dashboard and click submit. Every effort will be made to answer questions near the end of our time together today. So now let's begin. John, I'll go ahead and begin unless you have any other opening comments.
No, that sounds great.
Okay, great. Well, again, welcome once again here to our presentation. There's a picture of John and me. Just topics for today that we'll be covering. I'll be doing the first part of the presentation on these exciting retirement plan topics, hardship distribution, IRS correction guidance, updates to the termination letter program, MEPS, we'll talk about what that means later on, and some other miscellaneous current and recent events. Then we'll turn it over to John, who's going to cover these hot health and welfare plan topics, including a legislative update, use of coupons for prescription drugs, exclusion of high-cost prescription drugs, individual coverage, health reimbursement arrangements, or ICRAs, I believe, how you pronounce it, and open enrollment communication reminders. With that said, we'll move on to my first topic here, hardship distribution. So many of you who have been following the law on this are aware that the IRS has been actively looking at hardship distributions and had some proposed regs out a bit ago already, but has recently issued final regulations. Really not much new from the proposed regulations in this case. The 6-month wait that those of you who have been in the industry for a while are familiar with is going to be required to go away for hardships in 2020. Again, this is really nothing new and shocking from what we had heard before. No need to take all loans available under the plan before hardship. But an important change, which again, I think some employers have begun to implement because you are permitted to implement at this point, is that earnings are now available for hardship distributions, as well as actually QNEX and QMAX and earnings and those amounts. An important distinction for our 403B clients, however, is the earnings provision, because of the way it was drafted, which likely was just so much going on, it was missed in the discussion. It doesn't apply to 403B plans. And again, this goes back to the law change that drove these regulatory action, which was a tax act in late 2017. Finally, the final regulations include that hardships can be available for federally declared disasters. So that's an expansion on where we're covering them. But importantly, and I think this is where most clients are asking us nowadays, we don't have an imminent amendment deadline. In fact, it looks like the earliest for individually designed plans would be the end of 2021, based on how the math all shakes out and the regulation being where it is. You may want to consider, that being said, amending sooner and talking to your providers or to us here, Quarles and Brady, to get those provisions in your plan, really for a few reasons. So you don't forget when you changed and what you're doing, and to make it clear between you as well as your record keepers what is and isn't going to be available. Because for the most part, with the exception of a couple of things like the 6-month wait, these are optional changes, and so there is a certain amount of time and ability to change them at various points during your plan's lifetime. Finally, we're expecting at some point, hopefully in the not too distant future, more guidance on how to and when we need to have amendments for 403B plans and pre-approved plans. My experience has been that for the pre-approved plans, rather, we haven't seen a lot of final documentations from our TPA colleagues who handle prototypes and volume submitter plans addressing hardship distributions yet. And I think that has a lot to do with the fact that these final regulations have just been issued. So look for that in the near future, especially if you're operating under one of those kind of plans. An important development we've had really in 2019 here is related to the correction guides. So like most plans out there, I suspect a majority, maybe virtually all of those who are listening in, have found little mistakes that happen because, hey, that's life, with respect to their administration of their retirement plans. Thankfully, the IRS has their guidance, the Employee Plans Compliance Resolution System, or EPCRS as we call it in the industry here, and gives a lot of different options for how to correct failures to follow your plan verbatim. And of course, most of those are suggested things, but you're allowed to use reason and come up with somewhat creative, although reasonable approaches if you don't happen to like one of the pre-approved guidance options. And our experience has been that the IRS has been generally open to having discussion on those, or where plan sponsors simply implement them, that the IRS may ask a couple of questions, but generally looks for good faith. And if they see good faith, they're pretty comfortable with it. Notably, however, here, the EPCRS did include a few significant changes that it did reflect in the actual document itself, several tens of pages worth of document. The first important one here: certain errors in plan loan repayment timing can now be corrected without formal IRS approval. Historically, when you had a plan loan issue with a plan, in other words, loans weren't being paid at the proper time, a pretty common one would be maybe that the employer never got them set up in the system. There was a problem with the schedule on the repayments, that the participant was out of luck. Essentially, they were going to get taxed on the value of the loan, or if they simply fell out of repaying it in a timely manner and didn't get back on track pretty quickly. The good news here is, excuse me, is that the IRS is becoming more flexible. Generally, if a payment's missed, payments are missed, you can now catch up or either in a lump sum or through reamortization the missed payments, as long as you're still within the period, the loan is entirely paid off within the period required for a repayment. So 5 years is the typical situation, except potentially in mortgage loan situations. So a big option to correct. By the way, that certainly doesn't suggest that we should be getting sloppy with these. I think that goes without saying, but just that when those kind of things happen, you don't automatically find yourself in a really uncomfortable position with your participants and the participants having a significant tax liability. Other kind of things along the same area where the IRS is now giving us a little more flexibility. You're now going to be able to report any taxable issues in the year of correction. Historically, we believed that if there was a problem with a plan loan and you discovered it a year or two later, you'd be having to do the reporting effective back a year or two, which would mean participants would have tax liability that was unpaid, potentially interest and penalties, and not to mention having to amend their tax return. Just a lot of really kind of messy and uncomfortable and really challenging stuff for the typical participant. So the good news is here, now under the new guidance, you'll be able to report that in the year that the issue is corrected, is addressed. Similarly with spousal consent, another kind of typical oops kind of thing that happens, forgetting to get spousal consent or simply overlooking it. as long as you can go back to the spouse and get the spouse to agree to consent to the loan after the fact, that's going to be good enough, and the IRS will allow you to do that. Importantly, by the way, these are things that I remind you, can be done without going into the IRS. Historically, there's been an ability to fix loan errors, but they've only been able to be fixed if you were to go in formally before the IRS through the voluntary correction procedure, which takes more time. In our experience, a year and a half is not unusual, maybe longer, plus a fee somewhere between $1,500 and $3,500, as well as your attorney's fees to get it fixed. Returning to our last item on the loan stuff, the number of loans. If occasionally plan sponsors have had a situation where they inadvertently, either through their own mistake or through an issue from the record keeper, have issued a second, third, fourth loan, whatever the number of loans are, beyond what the plan actually says. And this is probably one of the situations where the plan sponsor says, yeah, we think we'll allow people to have a second loan, but for one reason or another, it never gets written into the official documentation. Similar to the other things we've talked about, the IRS now will let you fix that kind of situation as long as you've been making that new number of loans available to all participants. So, for example, if your plan allowed one loan, now you've decided you've been allowing people to take two. As long as you've been allowing everyone to take two loans, you're in the situation where you can amend your loan policy retroactively without having to formally go before the IRS. Moving on to the second point under here, plan sponsors often may amend their plans retroactively to match how they were operated, provided the amendments made within certain correction periods. So here's the thing, a very common problem we run across is where plan sponsors simply thought the plan said something different than it did. It happens, right? It's one of those things where everyone thought it said X, but in fact it said Y. And so all the communications, all the information provided to people all said that the plan was being operated in a particular way. The only thing that didn't say that, oddly or ironically enough, is the plan itself. So what are our options there? Well, if the correction could have been made, or is made within the period for self-correction, the amendment that is, which would be in the case of an insignificant issue. Insignificant, I would say, is generally fairly a gut feel that this really isn't a big deal or a lot of money. The IRS gives some guidelines, but they really don't give us anything particularly useful. You can make that at any time. So if it's a really minor thing, you can make that at any time. If it's a more significant thing, you doubled your profit sharing and increase in fully vested people, things like this that maybe just got overlooked. Those things can be made, and you have a fair amount of time there too. It would need to be made by the end of the second plan year following the plan year the error occurred. For example, if your calendar year plan year and the error occurred today in October of 2019, you would have until the end of 2021 to make that kind of amendment. The requirements are, there's always a little quid pro quo, that you have to be increasing a benefit right or feature. You have to be moving in the positive, adding flexibility, adding benefits in an upward direction, and in a way that's not a discriminatory way. That usually goes without saying when it comes to the IRS's correction guidance. It has to be made available it has to be an issue that was available to all eligible employees. It can't be just, again, sort of most offensively to just highly compensated. And it would have to be made in a way that a plan could be permitted to be amended consistent with the Internal Revenue Code. So that's really our second major learning from this correction guidance. And finally, another one of these kind of oops things are when certain required non-discretionary amendments, like those where you're making an amendment to have the plan reflect law. Ordinarily, the time frame was relatively short on that. But the guidance makes clear that you could, provided you have a determination letter or the equivalent of that, like a pre-approved plan would have, you have until the end of the second plan year after the time the amendment should have been adopted in order to have the plan reflect that. So that gives plans a good amount of time to get cleaned up. And again, historically, you would have been going before the IRS and paying your fees and going through all the administrative hassle as well. So good news there. Moving on to our next page here, IRS Determination Letter Program. Excuse me. So This is really less and less an option for plans. Historically, plans could routinely submit for a determination letter. And what that determination letter would get a plan is comfort that the IRS looks at your document and says, yes, this meets all the legal requirements. Now, you may still administer it incorrectly, but in fact, the document meets all the documentary requirements. And if you follow your plan document, you should be in good shape, and the IRS shouldn't have a basis to challenge you. The IRS, for financial reasons, has backed off of that, and so they no longer allow plans generally to request determination letters. They also, so now they're back to a situation where you can apply for a determination letter essentially at cradle and at grave with the determination letter program. So the start of a plan and at the end of a plan's life. Now in 2019, the IRS expanded it in a somewhat limited way in certain corporate merger situations. So buying a company, for example, where you're going to be merging the plan. Plans, if the plan is merged by the end of the plan year, following the plan year or the corporate merger, so if it were to happen today by the end, if a calendar year situation, by the end of 2020, you would be able to submit for a determination letter by the last day of the first plan year that begins after the effective date of the plan merger. So if the plan merger didn't happen, you didn't merge your plans, maybe your companies came together today, you didn't merge the plans until January 1, 2020, you would have until the end of the first plan year that begins after that, which could put you out to the end of 2021. A good deal amount of time to submit for that determination letter. And one little sort of sneaky tip of the trade here is if you're doing that, you can also sneak in other amendments for get the IRS approval on it. In other words, if you're doing your merger, your plans, and you want to get some other amendments in there and get the IRS to sign off on them, it's a perfect opportunity to make sure those are in there. And then you really get a broader coverage than just that your merger was okay. So you get not only that your merger of the two plans is okay, but also other amendments that you've done, which is kind of a nice little way of getting a little bit of what you used to be able to get in the old-fashioned IRS determination letter program. With respect to statutory hybrid plans, you're talking plans like cash balance, some kind of specialized defined benefit plans, pension equity plans, that you are also able to submit for a determination letter through the end of August of 2020. A topic that's been a little bit of a hot topic, really for various reasons, are multiple employer plans. This is another way I think the government looks to expand opportunities for people to have plan coverage into a broader realm. So in the multiple employer plan area, the idea is that you have multiple number of employers, different employers that are not legally related at the level the IRS considers them to be the same organization, which is generally 80% common ownership. When you have that situation, if those two different entities, two different organizations, corporation A and B, participate in the same plan, but they're independent organizations otherwise, the plan is classified as what's called a multiple employer plan. The upshot of that is that some of the testing works differently, and that and historically the big challenge there is that if corporation B handled the plan incorrectly, corporation A would get dragged down into the morass along with corporation B. And when you think about these plans, if they covered a whole boatload of different organizations, lots of them could get dragged down by an error or mistake or other sort of wrongfulness done by one particular employer. The recent guidance from the IRS has given a certain amount of comfort now, provided the plan sponsor moves at a relatively decent pace and makes this certain steps like either spinning off, terminating, or correcting the bad apple. The guidance is going to presumably allow plan sponsors to preserve their plan qualification. It involves a sort of a series of sending letters to the bad actor, telling them to get their act together essentially and get things fixed up. But if at the end of the day that doesn't happen, there are ways to actually sort of break off the bad actor, bad plan, and set it aside. Notably here, by the way, these are still in flux. The regulations, by their very terms, cannot be relied upon. So there's nothing that we can necessarily do at this point with formal IRS approval of the situation. But it has been a way that I think some plan sponsors have tried to do it historically anyways, even though the IRS hasn't gone down the road of making it more formal until recently. DOL, for their part, has also been doing a lot of looking at MEPs, multiple employer plans. And really in that category, it's how do you define who the plan sponsor is? Historically, the Department of Labor really was looking at, do these entities have something in common besides just wanting to have a plan? Do they have some business type relationships, similar industries, that kind of thing? This concept of open MEPs, where it would really be just somebody sponsoring the plan, and employers can kind of come in the door and latch on and say, I don't want to have to deal with all the hassle of it. The open MEP concept is being sort of bandied about, and it really is in flux as to whether the Department of Labor is going to move more in that direction, and they've asked for comments. So we'll see. There's a lot on the multiple employer plan guidance that is kind of in the we'll see. But for employers who may be considering that, it's something to keep your eye out for. Fiduciary rule, just a brief pass by this. As I think many of you know, the fiduciary rule Department of Labor rule is dead. The SEC has done some guidance, regulation best interest they call it, and it's really aimed primarily at the retail market. So kind of communications between brokers and your plan participants. It probably won't have a direct impact on your plan in a significant way. But again, happy to discuss that with any clients if they want to. The most important part really is remembering that the DOL conflict of interest regulations, the fiduciary rule, is no longer around. And really right now, I think we're still in the learning and seeing if anything else is going to happen on regulation best interest or other sort of similar type guidance, if it'll ever be expanded in a way that'll come anywhere near to what we were looking at previously with the Department of Labor. I'll talk briefly about the Secure Act. This is a piece of legislation that is treading water right now. And I think the general feeling in the world is if this doesn't happen by the end of this year, it may not happen for a while. The Secure Act, because come 2020, politicians are focused mostly on being politicians after the election as well. The Secure Act is a piece of really highly supported legislation, but got kind of hung up in the Senate after it passed nearly unanimously in the House. So a couple of the items here, some are listed here. I've got a few more to mention besides that are of interest to most employers, should they come to be. And I think that the thought is that at some point they will come to be, unless the world takes a significant turn. The requirement to provide an estimate of lifetime income based on a participant's balance in the defined contribution plan. And while the Department of Labor would need to issue regulations, this gives people an idea if they were to take their balance of $50,000, $100,000, whatever they saved up, what could that generate for them and potentially, I suppose, their spouse or any other type beneficiary. Really give people an idea what it means to have a balance of $50,000 or $100,000. And importantly, really in that regard, for some people, to understand that if you don't have a big number, you've got to start planning now so that you're ready when retirement comes. It would add a safe harbor, an option for annuity option, a safe harbor option for annuity options offered in a plan. So this would give plan sponsors who are going to have to pick annuities if someone were to elect a new annuity, a little bit simpler of a process and more assurance that the annuity they picked is not going to get challenged as, well, why'd you pick that annuity provider? That one wasn't the right one, wasn't a good one. Give plan sponsors a little more comfort in that regard. Potentially allowing some portability of lifetime income options among employers' plans when employees switch from one employer to another. And then changing the maximum time frame for required minimum distributions after a participant's death. These historically could drag out for extended periods of time. The new law, as would be applied to defined contribution plans, would really generally, with exceptions for some spouse and family members, limit the distribution period to about 10 years after the participant's death. Correspondingly, however, increasing the required minimum date to age 72. Right now, as you recall, it's age 70 and a half. I think really probably in recognition of people working longer to be ready for retirement and not necessarily needing that money at 70. Kind of a nice little bonus one here, penalty-free withdrawals for $5,000 in connection with newborn or adopted children. Really a minor carve-out in some ways, but for people who are looking to do that, sort of an indication that Congress would support that and want to make it a little more feasible for people who are deciding to go that direction. In addition to those things, there's a couple others that are probably worth noting. For long-term part-timers you may have, after they worked 500 hours in 3 consecutive 12-month periods, they would be allowed to get into the plan's deferral provisions, the 401k deferral provisions, for example, in a 401k plan. A nice way of recognizing that these people probably need some kind of option. It doesn't require you to expand it generally to the other employer contributions you would make, at least not as I believe it's currently drafted. But it does give them an option to have some sort of retirement savings commencing. It would increase the QACA maximum from 10% to 15%. So this is for plans that use qualified automatic contribution arrangements where people can gradually be brought up to making 10% of deferral contributions. This would allow employers to, instead of being maxed at 10% for how high they can move employees up to, that they could in fact move them up as high as 15% of their pay. We'll see how much interest there is in that sort of thing. An important one, though, is eliminating notice requirements for a 3% non-elective safe harbor advanced notice requirements. So currently, if you're going to have a safe harbor plan, the notice requirements need to be satisfied before the beginning of the plan year that the safe harbor is going to apply to. If this legislation passes, with respect to the non-elective kind, where an employer makes 3% contribution profit sharing, some employers refer to it as, that's going to take that notice requirement away as long as it's taken care of and amended within 30 days before the end of the plan year. In fact, there's even an option to go beyond that, where if you go up to 4%, but all that's a kind of a wait and see if that all makes it through to the final legislation. The important thing I think on that is really recognizing that what becomes a trap for the unwary, as attorneys like to say, about not getting notices out in a timely manner, we would be able to knock that off the list and have that taken away from us and have a better way to make non-elective contributions for a safe harbor plan. Uncashed checks, some guidance came out, I think generally as a surprise to nobody, that uncashed plan checks, if a plan sponsor has those paid out to people, they're going to remain taxable in the year of issuance, even if they go stale. So if checks going out in December, the check goes stale because the participant doesn't cash it, that's still going to be a 2019 event, not a 2020 when the check gets reissued. One thing I didn't see in here is IRS looking at uncashed direct rollover checks. We'd see this come up back in my prior life as the trustee and record keeper, where someone would get a rollover check because the rollover was processed as a distribution to the participant, who would in turn take it and deposit it to pick an IRA provider, and the check would go stale. And the people would say, well, gee, the money's been out of the plan for over 60 days. Are we concerned? Is there a taxability question here? The IRS actually did issue a private letter ruling some years ago where they essentially said you could reissue that check to the rollover institution as a replacement check and not have the unintended tax consequence of having a taxable distribution because the check wasn't properly rolled over within 60 days. So this particular point, not particularly relevant to 2019-19, but it is something that comes up from time to time with TPAs and participants who elect direct rollovers. Student loan repayments, this is a gimmicky kind of thing that some employers and law firms are looking at. So allowing the IRS agreed to allow matching contributions to be made to a plan where a participant, where the plan provides for this, by the way, and a participant makes student loan repayments equal to the amount or more than the amount of the deferral that would have been necessary to get the match. The employer then contributes a match that's like the amount that they would have gotten if they would have made that amount as a deferral to the plan rather than a loan repayment. Creates some interesting testing situations because the match isn't really a match anymore. Now it's more of an employer contribution. I think it's one of those things that, at least thus far, as far as our clientele have been concerned, we haven't seen a lot of uptake and interest in. But there might be some creative ways of starting with that approach and applying it to other factual scenarios. With that, John, I think I'm ready to turn it over to you to move into the health and welfare side. If you're ready to go, I'll click to the next slide and let you handle from here.
Okay, sounds good. Thanks, Mike, and thanks everyone for being here today. I wanted to lead off with a couple of slides on fiduciary issues, fee monitoring questions. And in the retirement plan space, as Mike knows, retirement plan fees are closely looked at by usually, the plan sponsors, perhaps the DOL, plaintiffs, lawyers. The health plan side of things, it doesn't raise quite the same concerns, but we have seen some interesting allegations recently. For example, Blue Cross Blue Shield of Michigan just agreed last year to pay $30 million to resolve claims that it charged self-funded employers extra fees under their health plans, where basically they would allegedly, and I guess this is what a court found, so it's not even allegedly at this point, perhaps, but they would say to a client, hey, the charge for this particular medical procedure is $1,100. In fact, the provider was only charging $1,000. And then they would keep the extra $100 as revenue. And the kicker is that it wasn't really disclosed in the contract. And so Blue Cross Blue Shield of Michigan has been having some issues with that. And it's not necessarily something that is uncommon. We're talking to a different TPA down in Illinois who might be doing the same kind of thing, and we're looking at it further. So again, trying to figure out what you're actually paying your vendors, it raises some interesting issues sometimes. Cigna 2018 also got sued by some plan participants over similar allegations that was charging extra fees for certain medical procedures. Cigna back in 2016 got sued along with 231 plans by health plan participants. Again, the allegation is that they failed to monitor Cigna's excessive payments to itself. Cigna was keeping a certain cost containment fee for itself if it negotiated a deal with non-network providers. Allegedly, Cigna was just sort of taking the money, but not actually doing the work. Again, that one I think is still pending, kind of a massive class action lawsuit there. 2018, various providers in Montana were sued by the health plan participants over the agreement that they entered into with Blue Cross Blue Shield of Montana. Supposedly, the deal was kind of a sweetheart deal where Blue Cross would give $20 million in kickbacks to the hospitals, and the participants' allegations is that, well, the $20 million comes from somewhere. It's coming from the fees that we're paying or the services that we're paying for here. So again, the argument is that these amounts really shouldn't be paid out to service providers like that. So again, interesting. We'll see if the trend continues, but again, we've seen sort of an uptick in cost-related litigation in the health plan context. Other things you should be thinking about in terms of like ways to reduce your fiduciary risk. Obviously, that's kind of the nightmare scenario from an employer perspective, right? You don't want to be sued for offering these benefit plans. So again, monitoring fees, very important. Also, I think just kind of taking a step back sometimes and kind of looking at your process, knowing what the law is, how do you follow the law, how do you look for changes in the law, updates to case law. Some of this is hard to keep track of, to be honest. There's a lot that's going on out there. Obviously, you can go to webinars like this and read, daily alerts and things like that, but there still is a fair amount going on. So sometimes we have seen clients do periodic reviews of whether their policies are being followed in practice, for example. We have a number of clients, we have hundreds of clients who use some model HIPAA forms that we have in place. And the question sometimes is, well, okay, we put these forms together several years ago, but is anybody actually paying attention? Should we do a training session? Should we do kind of a self-audit to make sure that we're actually following the procedures that we have in place? Again, good idea. No lawyer is probably going to tell you to not do that. It seems like a good practice in general. Also, take a look at your plan document and SPD to make sure that they have kind of the best-in-class language. For example, occasionally we still see plans that don't have something called Firestone language. Firestone is a very old, I think it was a 1989 Supreme Court decision in which the court said that if you, as a plan administrator, give yourself discretionary authority to interpret the plan, then you're likely to win in future lawsuits. And so, again, very good idea to have that kind of language in there. In addition, there have been some trending language cases out there that we wanted to highlight for you. For example, some courts have upheld anti-assignment language where if I'm an employee covered by the plan, my health plan at Quarles, let's suppose I go into a provider and the provider has me sign a form saying, in the event of a payment dispute, you agree to assign your rights to us, the provider, so that way we can, kind of step into your shoes and try to recover the amounts. A very common situation when you go to visit, a hospital and have an expensive procedure. Some plans have pushed back against that under the theory that, hey, if there's going to be a dispute on this or litigation, we'd rather, fight the not deep-pocketed employee like me versus taking on a large healthcare system which has deep pockets. And some courts have, again, upheld this anti-assignment language in kind of some recent decisions. In addition, one other kind of interesting case, again, came out last year. Epic Systems, Supreme Court ruled that class action waivers in employment arbitration agreements don't violate federal law and are enforceable. That had been sort of an open issue. In addition, the Ninth Circuit a couple months ago upheld arbitration provisions for ERISA plans. And so, again, the concept here is that we would perhaps start building into our ERISA covered plans a provision that says that you can't bring a class action lawsuit, and in fact, everything has to go through arbitration before you can actually do anything. So, in other words, arbitration kind of steps in lieu of a lawsuit, at least initially. So, again, this is, I think, kind of a trend. We'll see how far it goes, but we're definitely seeing a little bit more interest in that concept. Other ways to reduce fiduciary risk. Another thing we talk to clients about is a venue selection clause, and venue relates to where litigation will occur. For example, suppose you have an employee who retires and moves to Florida. The employee then brings a claim under one of your plans and files a lawsuit in Florida. Can you force the employee back to a Wisconsin court if, for example, you're based in Wisconsin? Again, or, substitute your kind of preferred jurisdiction, Illinois, California, Washington, whatever it is. And a recent case in the Seventh Circuit upheld a venue selection provision in an employee benefit plan governed by ERISA. Court followed a similar decision from the Sixth Circuit that held, yes, this is okay. And so this one I think is going to be pretty popular because you can see pretty easily where, again, if you have a disgruntled former employee who's bringing a lawsuit against you, you'd much rather fight it in your backyard, if you will, so that way you're not traveling, your staff isn't traveling, things like that. So this one I think will actually be fairly popular. All right, well, let's change gears a little bit here, talk about some legislative updates. Healthcare continues to be a big push in the early presidential campaigns here on both the Democratic side and the Republican side. Democratic side, obviously a lot more kind of creative ideas out there. Medicare for all, early Medicare buy-in. One big issue was whether or not private health insurance would be eliminated entirely. So again, would employers, would our clients be banned from offering health insurance to employees? We'll see. I mean, I think we're still pretty far away from that. On the Republican side, discussions of some healthcare topics, but no large overarching changes are being pushed right now. So again, little kind of nibbling around the edges here, but no radical overhaul on the Republican side. There has been significant House bipartisan support for getting rid of the Cadillac tax. You may have seen a couple months ago, the Cadillac tax, which is that excise tax. The House actually did something on a bipartisan basis, surprising. Normally Democrats and Republicans, struggle to find anything in common, but they both agreed that, yes, this 40% excise tax on high-cost health plans should be eliminated. In addition, there's been bipartisan support to prevent surprise medical bills. What they mean by that is the concept that if you are an employee in the plan, you go out of network, and then you have kind of a large bill, that's not fair, that you shouldn't have been expecting it, that you wouldn't have known is going to be so big. And so again, there's some efforts to try to get rid of those kinds of bills, mainly by having them be treated as in-network instead of out of network. Presidential orders. There have been a couple of presidential orders from President Trump which have changed little aspects of health plans. So we thought we'd walk you through some of these kind of changes. First of all, 2017 order from President Trump saying, hey, let's expand HRAs, health reimbursement arrangements. Let's create association health plans, kind of like what Mike was talking about in terms of, again, multiple different unrelated employers jumping together on the retirement plan side. The administration has also tried doing that on the health plan side, again, allowing unrelated employers to kind of have one health plan band together, and the theory is they'll have more bargaining power to offer better benefits. 2019 order has different aspects to it. Hospitals posting standard charge information, which hospitals in general are not very happy about. Self-funded plans, insurers, and providers have to provide expected out-of-pocket costs before participants receive care. We don't have anything really about what that means. For example, would that require you have to update your SBCs and provide more information? Again, we don't know quite yet. Expanded definition of preventative care for HSA purposes, we'll talk about that. Direct primary care, again, could be some changes there, and increasing the health FSA carryover amount. Again, we haven't seen anything on that yet. So what have we seen? Well, some action by regulators in response to the orders, but some of these are still open. Association health plan rules were finalized in June of 2018. And again, would have allowed for unrelated employers to kind of band together to provide health insurance or even be self-funded. This rule, though, was challenged by the states, saying basically these employers really don't have anything in common. They really should not be banding together. And a court in 2019 effectively halted the rules. And interestingly, the Trump administration did not seek like a temporary injunction. They allowed the rules to basically stop and kind of be frozen in place. They did file a formal appeal, so we'll see, where it goes. But interesting that they kind of conceded, hey, let's just put a pause on this for now. So again, we'll see where that goes. HRA changes. Again, kind of following up from President Trump's order, the regulators came up with sort of a brand new idea in some June 2019 regulations for individual coverage HRAs or ICHRAs and accepted benefit HRAs, as we'll talk about here in the next slide. So ICHRAs, the basic concept here is that let's suppose that an employer says, hey, we want to get out of the health plan game. This is too much work, too much risk, whatever it is. Let's drop our major medical plan, but let's give money to employees and let them shop for their own individual policies. And then we'll reimburse them for those policies. Under the Affordable Care Act, that was difficult to do, basically illegal, essentially. And this new rule kind of flips that and says, no, if you meet these different requirements, then you can do that. You, the employer, can, again, reimburse employees for these individual policies. Several hoops to jump through. For example, you have to do this on kind of a class-by-class basis, meaning like part-time, full-time, et cetera. And within that class, if someone is being offered an ICHRA, then they can't be offered traditional major medical plan coverage. Employees have to be able to opt out of receiving this ICHRA, i.e. whatever the employer contribution is. Employees have to certify that, yes, I did go out and buy this coverage. They have to give you proof of that coverage, and then you can reimburse them for that cost. The coverage, we think, generally will help employers meet that 95% test under the employer shared responsibility rules, where again, as long as you are, meeting, offering 95% of your full-time employees good medical plan coverage, then you won't be hit with an IRS penalty. So we think that this is probably where we may see some employers kind of be most interested in this. If you're offering coverage maybe only to 90% of your full-time employees and you're potentially putting yourself at risk for a big IRS penalty, you may be able to kind of bump this up and say, okay, for this class of employees, this extra class, let's offer them an ICHRA, maybe get our 90% up to 95% or 96% so that we're meeting that test. Also, a couple weeks ago, we just saw some new guidance on how to determine if the ICHRA provides affordable coverage, which again is another aspect of this employer shared responsibility rule. All right, accepted benefit HRAs. So what these are is basically an HRA which is kind of limited in scope, where again, the concept is will allow an employer to put in this case, a limit of $1,800 per year. And then the employee can go and buy their own accepted benefit coverage like dental or vision plan coverage. Again, similar rules, has to be offered to, one particular group of employees, has to be available on a uniform basis within that group, things like that. So there are some hoops to jump through. Again, we'll see if employers end up being kind of interested in that one. All right, changing gears a little bit here, preventative care coverage. A lot of our clients have high deductible health plans. They put those in place so that way they can encourage people to contribute to a health savings account or HSA. And one of the requirements of an HDHP/HSA is that you can't provide medical care under the plan until the deductible is met. Employees have to have kind of some skin in the game is kind of the phrase here. So again, until that deductible is met, you're not getting coverage under the health plan. But there's always been an exception for preventative care services like immunizations, annual physicals, things like that. And so that would include, for example, newborn baby. Let's give them a shot that'll cost 50 cents and it'll prevent some major medical issues down the road. Again, that's an example of preventative care. Some people have argued that it should also pick up what I call secondary preventative care. For example, let's suppose that you have a diabetic person and they fail to take insulin. That could lead to other complications. So normally taking insulin treats the diabetes, and that is exactly what you're looking for. But the argument is, well, okay, but if we don't take the insulin, it'll lead to some other situation. Therefore, we are preventing that other complication of diabetes. The IRS has always rejected this argument. They said, no, under that argument, everything is preventative in some sense until you're dead and they do an autopsy on you. That would be the only non-preventative benefit out there would be the autopsy. So IRS has always pushed back and said, no, not a chance. But the IRS came under pressure from President Trump to expand this for certain chronic care conditions. And so what they did a couple of months ago back in July was they came out with this list on the next slide that we'll show you in a second and said, hey, if you want to, you can now offer these additional preventative care benefits under your HDHP. Do not have to, but if you want to, you can. You also don't have to treat it as preventative care from an ACA perspective. So again, if you're looking to kind of bump up your HDHP coverage, provide a little bit better coverage, maybe on a preventative care side than what you were doing before, here's another option for you. Again, maybe look at it, if you have a calendar year plan, maybe consider adding this. Again, you do not have to, but I think in general, employers will probably be, pretty receptive to this. All right, let's talk about, again, kind of high-cost drugs and coupons. So again, staying in the health plan context, we've had a number of questions come up from service providers, PBMs, TPAs, and employers about the use of coupons for high-cost prescription drugs. And this trend has sort of taken off in the last several years. I did a little bit of research, meaning I Googled it, I guess, and back in 2009, there were fewer than 100 brand name drugs that had coupons. By 2015, we're looking at over 700 different drugs, which is about 20% of all prescriptions, had some type of copay assistance. And let's give you kind of a concrete example so you understand what copay assistance is if you haven't run into it in the past. Let's suppose that Ed is an employee of Acme Company and is in the Acme Company prescription drug plan. Ed uses a particular drug which costs $5,000 per week, so a pretty expensive drug. Drug manufacturer offers a coupon, though, which brings the cost of the drug down, at least for the first few months, to $5 per week. So it's worth $4,995 in this scenario. Ed goes into his local pharmacy, picks up the drug. Let's assume he has no copayment or coinsurance under his plan. Assume the plan's deductible is $3,000. Out-of-pocket maximum is $5,000. All right, so Ed pays his $5, reaches it into his wallet, and takes out a $5 bill. Plan gives him the credit for the $5 towards the plan's deductible and the out-of-pocket maximum. But does the plan also have to give Ed credit for the $4,995 coupon payment, If they do, then Ed will have already satisfied his deductible. Pretty good deal for Ed. He reached in, paid $5, and suddenly his $3,000 deductible is satisfied. In addition, he's really essentially at his out-of-pocket maximum also in that scenario. Typical plan position is that the coupon does not count towards deductible and out-of-pocket maximum. We have seen some situations where folks have given credit in the past for that, though. Fast forward to April 2019, the Center for Medicare and Medicaid Services, CMS, came out with some regulations. In the preamble to the regulations, they said that insurers and self-funded plans, including ERISA-covered plans, must give credit for the coupon in some situations, which caused a little bit of panic here because, how do you communicate this in the SPD? You have to give examples. It becomes kind of complicated because you don't know what coupons are out there. Those coupons could change at any time. So again, immediate issue, SPD communication issues. Also, if you have a high deductible health plan, it would seem to blow up the high deductible health plan because the IRS guidance says that only amounts that the enrollee pays counts towards the deductible. So again, if I have, my employer pay, $4,995 for that drug, that doesn't count. I'm still at $5 in terms of me getting towards the deductible. So again, the IRS guidance really kind of focuses on what you as the employee have paid. So it kind of created mass confusion. There's also an argument that CMS actually doesn't have authority over ERISA plans, which is totally true. So again, kind of mass confusion. August of this year, IRS DOL CMS put a pause on this, said, nope, don't worry about the CMS guidance. We'll give you more guidance probably later this year, maybe early in 2020 to be effective in 2021. So again, no action items required of you here, just kind of monitor it, just giving you a heads up about it. Other high-cost drug issues, though, there is a growing concern among employers about high-cost drugs. Includes gene therapy treatments, which aren't really drugs, they're kind of more treatments, I guess I should probably say. Some of these are really expensive. For example, Zolgensma, we've dealt with that a couple times with some clients. For infants with a condition called SMA, it costs $2.1 million. And if the infant gets that treatment, the infant generally will survive. If the infant doesn't get that treatment, the infant will die. And so, employers are kind of faced with sort of a tough decision here. Do we want to pay the $2.1 million and have the baby live, or do we not want to pay it and have the baby die, is kind of what it comes down to. So it's a tough one. There are also lots of other similar drugs in the drug manufacturer pipeline. The manufacturers see this as a very nice source of revenue that's out there, and it can be expensive. There was an August New York Times article about an Ohio Boilermakers plan with 3 family members, each of whom had the same medical condition that was inherited, each of whom had a $2 million per year bill for Strensiq. So it turned out that the 16,000 members of the Boilermakers are paying basically 35 cents per hour per individual just to pay for the medical costs of this one family. So again, really big dollar amounts potentially at issue here. So what does it mean? It means that employers, of course, are going to look to control those costs and look to ways to kind of minimize that risk. A couple of quick thoughts here. First of all, do check your stop loss policy if you have self-funded health plan and if you have a stop loss policy, because again, sometimes those might be excluded in terms of specifically kind of being lasered out. Some self-funded plans have begun excluding coverage for them, raises some concerns under the ACA, which we think you can usually get around. ADA, HIPAA non-discrimination rules. Employment law issues are also possible. Again, there are some considerations here. This is not, a 0% risk kind of situation, but on the other hand, it's not 100% unlawful either. It's going to be one of those where there's a little bit of gray area out there. Also, verify the process for reviewing claims. Again, if you get one of these claims, make sure that you clearly follow your plan document and SPD. You don't want any glitches in your procedures. If it's supposed to go to a benefits committee, it goes to the benefits committee. If it's supposed to go to the TPA, it goes to the TPA. Again, don't mess up your procedure, because if you do, then suddenly you could have someone claim, hey, you weren't following your procedure, and therefore the rules here really shouldn't apply. All right, wellness update, just a couple comments on this. First of all, wellness rules remain jumbled. As you probably all recall, they got tossed out by the EEOC. Wellness rules got tossed out by a federal court. EEOC is supposedly working on new rules. We don't have anything yet. So again, kind of status quo there on that aspect of it. Again, keep monitoring it, but nothing has changed since last year in this area. Mental health parity update. Mental health parity rules were updated a couple of years ago. They continue to focus on them. They get, again, I think 1/2 of all DOL audits and penalties related to mental health parity. Again, look at this, talk to your TPA about it, talk to your PBM about it, see if they're doing the test. If not, you're going to have to step in here. One other kind of bad mental health parity case, a case that came down in March called WIT, and this was out in California. United Behavioral Health, UBH, had put together guidelines and was following those guidelines, but the guidelines were challenged as kind of favoring the plans in this situation. And I think it's kind of a bad decision, but basically it threatens employers out there where, again, if you have even written policies and procedures, you could still be challenged here, or your TPA or your PBM could be challenged here. So difficult one to kind of reconcile, unfortunately, which again, I think just emphasizes the risk in this area. Last slide we had here before we'll open up for a couple questions, open enrollment materials. Again, main thing here is make sure that you have all of them, that they're in clear form, that they're written well. Nothing has really changed here. Last year we had an update to the employer marketplace notice, but that's basically it. So again, there haven't been any significant changes here in 2019. So if you looked at your forms recently, like in 2018, you should be in good shape. If it's been a couple of years since you looked at your forms, probably go through them again, make sure that they are all up to date, etc. And with that, I think we have a couple minutes for questions here. Mike, have you seen anything come in?
Yeah. Right, we have two questions. John, you should have one, I believe it, but while you take a look at that, I can address one that I saw come in here. It was really related, I think, to counting hours of service. And in determining 1,000 hours of service for an employee to become eligible for the plan, are those just worked hours, or would they also include hours like for vacation, sick time, and so forth? So, right, you start from the perspective of it's going to be your worked hours, but also hours, you also include hours for which an employee is paid or entitled to payment, to quote the reg exactly, for periods during which no duties are performed because of vacation, holiday, illness, incapacity, layoff, et cetera, with a limit of not needing to credit more than 500 hours of service for any particular period where no service is performed. You know, I guess one other thing to keep in mind in that regard is to look at how your plan calculates hours of service, because a lot of plans use equivalencies in some cases. So if you, for example, some plans will use what would be a weekly equivalency. So any week that someone works 1 hour, they get credit for 45 hours. That's whether they work 1 hour or 60 hours. And sometimes that's limited to just certain classes of people. So it is something that you need to check your plan document on to make sure that you're doing it the correct way.
Okay, great.
John, I think the next few questions are for you.
Sure. Yeah, and I see one on the Cadillac tax, and it says the Cadillac tax is for high cost, generally executive plans, and that we're going to get charged if employers continue to offer these plans, correct? And I think that is probably true. At least that's how it was kind of positioned or sold, is that, hey, this is for these gold-plated executive plans. But the limits, I think, would affect most employer plans within the next few years or decade or so. So, in other words, the way that these numbers adjust, most consultants were of the opinion that this would actually catch, even kind of the silver-plated plans, if you will, pretty quickly. And then the worry is that eventually they catch the bronze-plated plans. So it's not just the gold-plated plans. And so this has been deferred. It keeps getting pushed out. I think the original effective date was 2018, got pushed out to 2020, got pushed out again in 2022. And I mentioned how, again, the House a couple months ago voted to just get rid of the whole thing. 419 to 6 vote. So what, huge bipartisan support. Republicans and Democrats both want it to be gone, but it's sitting in the Senate. The Senate hasn't taken it up yet. So again, it has not been officially eliminated. Again, that's kind of an issue, I guess. One other, and it's the top of the hour, so we'll let you go, but I think there was another question or two here that I just wanted to go through. The first question I have, again, if you're sticking around, is do you have suggestions for employers when their TPAs/carriers will not do a mental health parity compliance assessment? This is a fairly common position. I think it's actually difficult for TPAs and carriers to do it, or PBMs to do it. And so we have had some employers, ask us to kind of step in and help out with it. So it's something we can do. I know consultants do that kind of work too. Some of the big, brokerage and consultants companies will do it. Some folks have used us because then you have at least attorney-client privilege, and it can't necessarily be discovered by a plaintiff's lawyer quite so easily. But again, if your vendors won't do it for you, it kind of does get forced back to you. Another question was, how do we get the required notices for open enrollment? And again, that's just kind of going through the different notices that are out there. So I mentioned before the marketplace notice, which is a new one under the Affordable Care Act, where again, you have to tell people, the exchange is available, things like that. That's actually available online. So there's a nice sample. Employers don't usually modify it, and that is what most folks actually do. Other notices, we have some clients who every year at open enrollment time redistribute their HIPAA notice of privacy practices. And again, so that's something you would normally put together. Why do it? Because then people have it, and you don't have to worry about redistributing it every 3 years or a notice of it, which is the typical rule. So again, kind of look at your bundle of notices. If you're not sure about it, obviously we could help, other folks could help too, but kind of go through and say, okay, how do we redistribute these notices? Mike, anything else that you see?
No, that's it. We haven't received any further questions. So thank you all for attending today. We really appreciate you taking the time out of your day. And you have copies of the materials. If you wish to listen to the presentation again or follow up with any questions, please contact John or me.
Thanks.
Have a good day, everyone. Bye-bye.